Hello, members. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everyone. And today we are jumping into Evidence Law 1, looking at the doctrine of judicial notice. We shall look at what amounts to judicial notice, how does it apply, and the legal framework governing it in Uganda. I urge you to like, subscribe, and share the video because that's the only way we can support the channel. I also urge you, if you need more, accompanying or private tutorial session, we are always available there for you. Our contacts are there down, and don't hesitate to contact us. Well, starting with the definition, it has been defined according to the Black's Law Dictionary 9th edition as court acceptance for purposes of convenience without requiring a party's proof of a well-known and indisputable fact. This is the formal definition according to Black's Law Dictionary 9th edition of the Doctrine of Judicial Notice. And in a layman's language, it means that this is a fact, a well-known fact, such that if it's adduced in court as a fact in issue in a given matter, court shall not require a party to prove it. Why? Because it's already a well-known fact and indisputable. For example, let's say in a given matter, the fact that Yoweri Kaguta Museveni is the president of this country is in issue in that matter. That fact is in issue in that matter. Court, if a party was coming to adduce it in court, court shall not require that party to give evidence for that or to prove it again beyond what it has given. Why? Because it's already a well-known fact. No need to prove much more formalities. We shall also see that it was defined in the case of Holland versus Jones as a judicial shortcut. So this is a shortcut that court takes to avoid wasting time, doing away with all those formalities of proving evidence of a well-known fact, because it's already well-known and established. You don't need to prove it in court. That is what we call judicial notice. And the basis of application of this judicial notice doctrine, it is based on two bases of application. First and foremost, we have the universal nature of the matter and the matter of common notoriety. And the major or the general rule governing this doctrine is found under section 55 of the Evidence Act, Cap 8, that stipulates that facts of which court will take judicial notice do not need to be proved. Further on, we shall see under section 56 that they lay down now these facts that do not need to be proven, or facts of which court may take judicial notice. They do not need to be proven if adduced as facts in issue in a given matter. And they are split into three categories: legal matters, constitutional matters, and customary matters. So, to start with legal matters, these involve, according to section 56 of the Evidence Act Cap 8, these involve all the laws in application in Uganda, all the laws of Uganda, all the laws of UK, but in force in Uganda, all the court seal, the statutory instruments in force in Uganda, the rules, the orders. So, court shall take judicial notice of all those. For example, in the case of Saleh Muhammad versus R, it was shown that section 57, subsection 1 of the Indian Evidence Act, its interpretation was the same as the interpretation of section 55, subsection 1 of the then Evidence Act. And it was shown that court took judicial notice of that, since it it didn't need to be proved again. So that is, in short, what legal matters would amount to. But I urge you to go further in section 56 and see all the details of what amounts to legal matters. Then to go with the second, we shall see constitutional matters. These are matters that refer to a title and a non-title, official, a national flag, a government, or hostilities, wars which involve Uganda, and these court may take judicial notice of these uh, because they're already well known. Let's say something that is already published in the Uganda Gazette, that so and so are nominated to be judges of the Supreme Court. If that fact is an issue, why would we again prove it? So court shall take judicial notice of such facts. Uh, it was so shown in the case of Duff Development Company versus Colathon government, where courts shown that uh, a title, an official title, does not need to be proven again because it's already a well-known fact. Uh, Lastly, we shall look at the customary matters. These are matters that are so not okay. These are rules or facts in in a certain custom that are so well known that they they have been known for so long, and they do not need again to be proven. Uh, for example, in that case of Angu versus Atta in 1916, where the court held that customary law must first be proved by calling witness acquainted with the native custom until the particular custom have by frequent proof in court being accepted and become so notorious that the court will have just to take judicial notice of them. Um, this applies to so many customs that are not written anywhere, but have been applied so many times that they are well known now, and they do not need again to be proven in court if at all adduced. And for a custom or for a customary fact to be taken as judicial notice, there are three things that are to be produced in court. So, and these were shown in the case of Chimani versus Gikanga. Customary law as a matter of judicial notice has to be proven by calling experts, adducing textbooks maybe that show those customs, calling persons that are acquainted in those customs, those natives of those customs. So members, that is in short what is judicial notice as a doctrine in evidence law. I urge you to again to like, subscribe, and share. That's the only way we can support this project, Agora Legis, the legal mindset. And I also urge you to go and look at the other channel, Legal Mindsets at the Bar, where Castle Hamza gives again more explanation about legal principles. Thank you for watching, and see you in the next video.